the court shall presume certain facts. And then the third category, there are certain conclusive proof. Now what is the distinction between these three? May presume means there is certain aspects which the court may consider under its discretion that these facts may be existent. Then there are certain facts which the Act says that the court shall presume. And what is the criteria? The criteria is Indian Evidence Act. That the facts which the Indian Evidence Act says that the court may presume, the court may presume. The facts which the Indian Evidence Act says shall be presumed by the court shall presume. And the third category is conclusive proof, where the court shall not allow any evidence to be given. It's a conclusive proof. So now what are these three categories? Now, there are certain things which are called the presumptions of fact. And there are certain things which are called presumptions of law. So what is the presumption of fact? Which the court may or shall presume, or the court will not allow any further evidence to be given. It's a conclusive proof. Now these three categories: the presumption of fact and the presumption of law. And there are further two categories under presumption of law: rebuttable presumption of law and irrebuttable presumption of law. I'll give you examples. Presumption of fact means that you need not to give any evidence. The court is presuming this fact to be true and existing. Now, the day is followed by night and night is followed by day is a fact. These are presumption of facts when you need not to prove anything. Now let's go to presumption of law, which I say is divided into two categories: presumption of law, rebuttable, and presumption of law, irrebuttable. So what are the principles of law which are rebuttable, which can be rebutted? A principle of law which the court presumes to exist can be rebutted. So which are those principles of law which can be rebutted? Can you imagine? These presumptions of law can be rebutted. For example, in the beginning of this lecture, I said that there is a principle of law that until proved guilty, a person is innocent. Isn't it a law? A principle of law. Until proved guilty, a person is innocent. So the court primarily presumes the person to be innocent. It's a principle of law. And this principle of law is open to rebuttal. Until you prove guilty, in my presumption of law, I consider him to be innocent. Isn't it? This is presumption of law rebuttable. For example, the presumption of a child born during the sustenance of a marriage is that the child is legitimate. It's a principle of law. The child born during the sustenance of marriage is a legitimate child, unless you prove the circumstances that no, this child is illegitimate. So when you prove before the court, then this presumption of law is rebutted. Are you getting the point?
Yes.
So these are rebuttable presumptions of law. And then comes the third category, irrebuttable presumptions of law. Those presumptions which the court does not allow to rebut, or they are not entertaining any rebuttal. They are conclusive proof, that third category. They are conclusive proof. And what are these presumptions of law which are irrebuttable? Any idea? Non-rebuttable presumptions of law are the orders, decrees, judgments of a court which are final. You, for example, now I'll exemplify. I suppose A moved a suit before the court that B is my wife, it should be declared. After the trial, the court found B to be the wife of A. And this decree was passed that B is wife of A. After few years, some C died. Intestate, having a lot of property. So this B claimed the inheritance of the property of C, saying that I am the wife of C. Now during this second trial, where the C is claiming to be the inheritor of the B is claiming to be the inheritor of the property of C, if the ancestors of C just produce this first decree of a competent court declaring B to be wife of A, this presumption of law cannot be rebutted. No further proof conclusively proved that a competent court of law has already declared you to be the wife of A. Now you cannot come and say that I am wife of C and I am entitled to inherit the property of C. Another rule is the principle of estoppel. Section 115 of the Indian Evidence Act. Estoppel, rule of estoppel, doctrine of estoppel means when you claimed something yourself, you cannot retrieve yourself from that. You cannot go back to your own words. That is called doctrine of estoppel, 115 to 117 of the Indian Evidence Act. These are irrebuttable presumptions by the court. Nobody will no court will allow you to challenge it. It's irrebuttable. Got the point? Now, in the relevance of facts, another category is called admissions. And in the series of admissions, there is an internal category of confessions. Section 17 onwards of the Indian Evidence Act, up to section 30, admissions and confessions are explained. Now the category of confession, although as a part of admission, is slightly different, because confession is only in a criminal trial. whereas admission is in the civil side. But as the name suggests, admission means when a fact is admitted by the litigant, then it need not to be proved. Once there is an admission, there is no need to prove that fact. For example, if A filed a suit against B